Good day, learners. Welcome back to study session 10. In study session 9, we learned about law of business organizations, and we talked about companies, how companies are formed, organs of the company, how the company comes to an end. In this study session, we're going to be looking at partnerships. Upon the completion of this session, you should be able to understand the nature of partnerships, explain how partnerships are formed, identify types of partnership, explain rules governing partnerships, describe nature of the business names, describe the nature of incorporated trustees, and discuss the establishment and functions of Corporate Affairs Commission. Nature of partnerships. A partnership is a relationship which subsists between two or more persons. A partnership is a relationship which subsists between two or more persons carrying on business with a view to profit. From this we can distill the essentials of partnership. First, it must be that two or more persons. Secondly, they must be carrying on business. And thirdly, it must be with a view to making profit. These are very essential. To determine whether a relationship is a partnership, there must be 1, 2 people together, 2, they are carrying on business, and 3, with a view to making profit. Now, a partnership can be formed. There's no hard and fast rule about the formation of a partnership, but generally a partnership cannot be more than 20 people. A partnership cannot be more than 20 people, except some instances that in the case of lawyers and in the case of accounting firms. Any partnership that is more than 20 for this will not be seen as partners because they are more. For instance, in Aquilos and IIT, the court held that a partnership consisting of more than 100 members is an illegal association. When we are talking about formation of a partnership, there's no formality to creation of a partnership, but it is essential to have an agreement, and the partnership agreement will set out the agreement of the parties, how the partnership is going to be run. Such an agreement is called Articles of Partnership. A partnership might be formed without having an agreement, a written agreement, but it is always better to have an agreement. And as stated earlier, when we're talking about law of contract, only people who have contractual capacity can enter into a contract. Thus, partners in a company, in a partnership, must have contractual capacity. However, a minor can enter into a partnership relationship, provided there are at least 2 members of the association must have contractual capacity. And where a minor is a member of a partnership, then the partnership agreement or the articles of the partnership must be certified by the magistrate or a notary public or a police officer. There are different types of partnership. We have the general partnership, we have the limited partnership, and we have the limited liability partnership. For general partnership, what it means that the liabilities of the members is general. There's no distinction between the partners in the business. The partners are all liable for the debts and obligations of the partnership without limits in their liability. For limited, the partners in general partnership, the partners are liable for the obligations of the partnership without limits. Every partner is jointly and severally liable for the debts of the firm, and such debt incurred while he is a member or is a partner for such debts that are incurred while he is a partner. Then we have the limited partnership. A limited partnership is a hybrid of general partnership and the concept of limited liability. It is a kind of partnership in which some of the partners have limited liability, similar to the limited liability companies, to the shareholders in a company. However, under this type of partnership, there are two classes of partners, because there must be a general partner who will be liable for the debts of the partnership. For the limited partnership, his liability is limited capital contribution by him, and such a partner does not generally participate in the management of the partnership enterprise. For limited liability partnership, this is a new one under our laws, under the Nigerian laws, though Lagos State has been having limited liability partnership law. But under limited liability partnership, it is a limited liability partnership is a body corporate formed and incorporated under the Act. It is a separate legal entity from the partners, and it is usually comprising of licensed professionals such as attorneys, accountants, architects. The partners in an LLP enjoy personal liability protection for the acts of other partners, but each partner remains liable for his own actions. A limited liability partnership must be created formally by drawing up a partnership deed, and it must be incorporated under the Companies and Allied Matters Act. A limited liability partnership may sue and be sued in its own name. It can acquire land, hold and dispose of property, whether movable or immovable. It can have a common seal. Classification of partners. We have active partners. Those are the partners that are actually participating in the running of the affairs of the partnership. Then there is this dormant or sleeping partner. So a dormant or sleeping partner does not participate in the running of affairs of the partnership. Then there is the nominal partner. The person is just a partner by name, probably to add value to the company. He does not have any interest in the business of the partnership, but lends his name to the firm without any capital contribution and does not share in the profits of the business. Neither does he have a voice in the management of the business. Then the limited partner is the one whose liability is limited to the actual contributions to the partnership. The determination of the existence of partnership. To determine whether there's a partnership relationship, there must be a contract for partnership, there must be an association of two or more persons, there must be carrying on of business, there must be profit sharing, and there must be mutual agency. If two friends decide to share an office without the issue of carrying on business together, profit sharing, such an association is not a partnership, though they might be sharing the same facilities, but it is not a partnership. The partners also have rights and duties amongst themselves. They have the right to equal share in the company, except it is stated in the partnership agreement. They have the right to management, right to remuneration, right to bring remuneration, right to view the books of the company, of the partnership, and an assignment of a share in the partnership. Dissolution of partnership. A partnership may be dissolved by expiration or notice. If the partnership is for a specific period of time, then it may be dissolved by the expiration of that period of time or by notice from either of the parties. It may be dissolved by bankruptcy or death of the party. It may be dissolved by the court, and the effect of dissolution, it may be dissolved by the court. It may be dissolved if the partnership is for an illegal purpose, then it may be dissolved as well. Aside from the last two that we've discussed, the companies and the company and the partnership, we also have business names. that or what we normally call ventures. A person might decide to register a business name to carry on his business. Anybody that is using a name to carry on business does not necessarily have to register the business name. But where the name goes beyond, but there are some instances where the name must be registered. Section 84(1) of the Companies and Allied Matters Act provides for where a business name must be registered. If it is a firm or partnership and the name does not consist of only the true surnames of all the partners without any addition, then the name must be registered. In the case of an individual, if the name does not consist of his true surname without any addition other than the true forenames or their initials, then in the case of a corporation, as a registered company, if the name does not consist of its corporate name without any addition, those do not require registration. But once there is more, then they must be compulsorily registered. Then, aside from business name, we also have what we call incorporated trustees. These are non-business and non-profit making organizations. They are formed under Section 283 of CAMA to facilitate the acquisition of corporate personality by a community of persons bound together by custom, religion, nationality, or any association of persons established for religious, educational, literary, scientific, social development, or charitable purposes. So generally they are formed for charitable purposes and not for profit making. They cannot make profits. They are for charitable purposes. Now, for incorporated trustees, the trustees are the only persons who obtain legal personality, not all the members of the. So for instance, if you see them, you see the registered trustees of so. The registered trustees are the ones who can sue on behalf of the association and who can be sued on behalf of the association. They do not do business and they do not distribute profits, and its income must be applied solely towards the promotion of its object. The Corporate Affairs Commission. When we're talking about companies, we've looked at the corporation of companies, we've looked at partnerships, we've looked at business names and also incorporated trustees. Now there's a body that is that has the responsibility of registering or incorporating these types of business associations that we've mentioned earlier, and that is the Corporate Affairs Commission. It is established by Section 1 of the Companies and Allied Matters Act. The latest act is the Act of 2020, and it is a corporate body corporate to perpetual succession on a common seal. The functions of Corporate Affairs Commission are stated in Section 8 of CAMA. It is to administer the Company and Allied Matters Act, and it regulates and supervises the formation, incorporation, registration and management and winding up of companies under the Act. It establishes and maintains the company's registry and offices in all states of the Federation. It conducts investigations in the affairs of companies. It performs such other functions as may be specified by the Act. It undertakes the other activities as are necessary and expedient for giving full effect to the Companies and Allied Matters Act. And generally, it acts as a regulatory body for corporate governance. The company is one of the regulatory bodies for corporate governance in the country. It regulates the affairs of companies and ensures that the companies act in compliance with the law. Thank you for listening.